Welcome to you all. I have been asked before introducing the illustrious speakers to mention our conference next week, 20th and 21st, which has 12 or more foreign speakers on questions of expropriation without compensation. It should be a mighty fine conference, certainly very interesting, and I'd recommend anyone who can set the time available to attend at least the 20th, day one, which will be people speaking about experience with expropriation without compensation in other countries, including various African countries, Venezuela, Peru, India, and then the 20th will be talking about solutions for South Africa. So bear that in mind. You can get all the details as usual on the net. Then I will welcome afterwards our foreign visitor, Dan Mitchell, who's well known to us in the Free Market Foundation and others in the free market penumbra. But I'm going to start with the first speaker, Frans who, sorry? Frans Rautenbach, not Frans Frans Cronier's, well, I suppose sort of former boss is with us here. But Frans Rautenbach, my apology, Frans. Frans is an advocate and a labour lawyer at the bar, at the Cape Town bar. He's author of his most recent book, South Africa Can Work, How a Free Market and Decentralised Government Will Make Us a Winning Nation. I can recommend the book. I haven't read it cover to cover, but I plan to do so over the silly season, but I have dipped into it and it's really excellent, a good read. He has consulted to the governments of Uganda and Tanzania on labour law, licensing, business laws, and something that's very dear to us. We believe we were primarily instrumental to introducing it to South Africa, and that is cost-benefit analysis applied to legal policy as a legislative policy tool. And the important thing there, by the way, is policy, not just law. Should always be subjected to impact assessment. In 2012, he appeared as part of the Free Market Foundation legal team on the labour law challenge, which got wide coverage, where we challenged one word in one section of the Labour Relations Act, Section 32, where the emphasis was on economic policy implications. And few people know actually what happened there. It was a new word for you to use at your next dinner party, an asculum defeat. Now, you've heard of a Pyrrhic victory. Well, very few people know what the opposite is, and it's an asculum defeat. And the reason I know you don't know is because I invented the term. The Pyrrhus had the Pyrrhic victory, meaning that they won, but they suffered so many losses that in fact it destroyed his country. And nobody knew what did the Romans have then. Well, they were defeated, but in fact won, and that's really what we have. It's completely changed the labour relations setup in South Africa. I had lunch today, Frans wouldn't know this, but with Gerard Papenfuss of NIASA, and they have used our case now successfully in various negotiations, various bargaining council processes successfully, and regard our case as having been an immense victory or an Asculum defeat from the Battle of Asculum on the Asculum River. So there's your thing. At the next dinner party, you just drop in the phrase Asculum defeat as if everyone should know what it means. I've done it, by the way. Nobody says, what on earth is that? They all want to pretend they know. So it's like Pyrrhic victory, which people use but don't necessarily know why it's called that. He has written two other books on labour law, Set the Workers Free and Liberating South African Labour. He has published on labour litigation, labour profit, and his favourite book of all, the one to which he attaches most importance, is called Your Kruger Park Guide. And he is a Kruger Park fanatic. And it's very, very embarrassing because Kruger Park, of course, belongs to the state and is against that. and Kruger Park was land expropriated without compensation and is against that. But nonetheless, this is his favorite place, and his favorite part-time is the Kruger Park. He's married with 3 children, a girl and 2 boys, and, well, now, of course, adults, and over to Frans to address us on the topic which you've all seen and what brought you here. Frans.
Thank you, Leon. I would like to start with an image, a metaphor. I'm going to talk about the rule of law, and I've been grappling with this idea of how to make it visible, how to make it concrete, to understand what is the rule of law and what is it not. So today I would like to tell you what the rule of law is, and I'll come to my metaphor in a second. And I would also like to tell you why I think it is indispensable to freedom and prosperity in our country and in any country in the world. My fellow speaker, who will be introduced, Dan Mitchell, will follow, and our agreement is I'm going to talk about this legal aspect with some illustrations here and there, why the rule of law works, and the 2 topics that we will both focus on as examples of where the rule of law works and does not work is property, a very topical matter, a current matter in South Africa at the moment, and then secondly we will discuss the issue of crony capitalism. I was rudely reprimanded before we started that I must not. Charles said to me, this is not crony capitalism, that is an insult to capitalism, it's cronyism. So if I lapse into crony capitalism occasionally, forgive me. Charles, noted. All right, what is the rule of law? Let me explain to you more formally what it means, and then I'll give you my metaphor. It is ruled by law and not by the arbitrary whims of people. That is my best and most concise definition, which means that there must be a rational basis for any decision, executive, legislative, or judicial. And what I mean by rational is all laws have a purpose. And the purpose is, believe it or not, that they must serve the interests of the people. And unless they ostensibly do that, and the process around the law is designed in such a way that they do that, it is not rational. It doesn't make sense. And I'll come back to this idea of rationality, because it is extremely important in making sense of this whole debate. Okay, now back to the metaphor. I like to think of the rule of law. Remember I said ruled by law and not by the arbitrary whims of people. Many years ago I bought a very good consulting book on business management. And the book dealt with the topic of a turnkey business. It's a business that you can sell to somebody and you say to him, here's the key and here's the manual. And let me show you step 1, step 2, and the procedures and the rules. And somebody can buy the business and they can take over the business, and the business runs itself and it remains as profitable as it was before. In other words, the managers don't sit there and take crisis decisions from time to time, change the rules, chop and change, make up their minds, don't make up their minds, and so on. It's not a people-managed business on the whim of people. They don't fly by the seat of their pants. They have a manual. It's almost like that. The business runs itself because there are rules in place. That is, to me, the sense of the rule of law. But that doesn't tell you much about how it affects people. And to me, what it's about is it's about the interest of self-determination. You know, in our Constitution we have human dignity as one of our core values, and we have freedom. And it's extremely important that we understand that these have a place in the sense that they stand at the heart of the notion of an improvement in our society. And I'll show to you why and how that works. Self-determination. In other words, making your life better, and for millions and millions of people to make their lives better, and progressively the collective well-being of the society improves. That's what you want. And I would like to demonstrate to you how that progressive increase in well-being of society is linked to the rule of law. So let me first just say to you what the content is of the rule of law, and I'll try not to be overly technical. Let's just give you a sense of what is it that we're talking about. One thing that rule of law is not is law and order. People confuse the two, and you'll see stories in the media, and there will always be somebody who says, we don't have enough rule of law. And what they really mean is the police are not strict enough, and they don't lock up enough people, and they don't enforce the law. That's what many people understand by the rule of law. It is not. So let me give you the content. There are a few basic things which we understand, and we sometimes take as axiomatic, but they are very often honored more in the breach than in the compliance. Power to make law resides in Parliament. That is important. Remember, I started out by saying self-determination. Now here's the starting point. Parliament, at least in theory, are the representatives of the people. They vote them in and they can vote them out. Of course, many people will say it doesn't happen sufficiently in South Africa. Why is the government not voted out when they do wrong? But in principle, at least, Parliament's accountable to the people, so the representatives of the people must make the laws, which has a twin requirement coupled with it, which is Parliament cannot, without very severe restrictions, delegate the power to make laws to other officials. So the minister and the minister's officials cannot simply go and make rules. Also, very often honored only in the breach. But in principle, subject to very severe restrictions only, delegation may take place to officials. Then another very important pillar, which is part of what is known as separation of powers, is that the courts have oversight. The courts must resolve disputes, and the courts must have oversight over what executives do. So if there's an administrative decision taken, that can be reviewed by the courts, it can be set aside and so on. That's a fundamental principle of the rule of law. All disputes of law must be resolved by courts. That's a really important one, and I'll come back to that when I discuss the idea of freedom and prosperity. All bodies with delegated power must observe due process. You know what that means. Fundamentally, it is the principle that you hear the other side. It sounds like such an obvious thing. Anybody understands it instinctively, and yet very often it is honored more in the breach than in the compliance. Procedural fairness is the other way. I'm a labor lawyer. We are inundated with the notion of procedural fairness. You hear the other side. And anybody will say to you, yes, it's a fair cop, but at least he should have heard my side of the story. We understand that. All laws must be clear and known. This is a really important one, and you'll see how it plays out when we look at property. All laws are clear, must be clear and known or reasonably knowable. Imagine if you go through, take this organization, through a day in this organization, and you are hauled in front of Leon on the red carpet because you contravened a disciplinary rule, and you say, well, what is the disciplinary rule? And he says, no, I'm not going to tell you. Or, I brought it in this morning, the contravention was last week. but I brought in the rule this morning, and I'm going to punish you and I'm going to fire you. Your first reaction would say, but that is grossly unfair. And it is. It is unfair because moral behavior requires that you can adjust your behavior according to your knowledge of what the rule requires. The only way that can be is if the rule is knowable or known. So that's a very important principle. And a corollary of that is you can't make a rule today and say it applies to yesterday or the day before when you misbehaved. That does not work. I have a recent court case in which the manager sent out a note after the event saying, henceforth, nobody will be permitted to make use of company facilities in order to do business in non-company related affairs. And then promptly went ahead and charged the employee for the offense. Obviously unfair. And then finally, one which everybody also instinctively understands is the idea of that laws must be of general and universal application. If there are rights, they must equally apply, and there must be equality before the law. They must not be discriminatory, and most importantly, and I'm going to come back to this word a lot, they must not be arbitrary, and the application of the law must not be arbitrary. My kids, my 3 kids that Leon spoke about, have an expression, their generation talk about random. But it's just random. And what they really mean is it's arbitrary. It's, again, coming back to the place where I started, it's not rational. It cannot be linked to the purpose with which the law is charged. Then it becomes arbitrary, or as they would say, random. So all these rules have things in common. They're all basically fair play. Your sense of fair play is satisfied by them. They all protect individuals' self-determination in their own interest. And thirdly, they all avoid arbitrary interference in those interests. So they're basically rules about protecting your welfare against the state. Basically, these rules avoid tyranny. Now, I bet you when I use the word tyranny, the notion that comes up in your mind is one of a cruel and wanton oppressor. It need not be. The real meaning of tyranny can be almost the kind of tyranny that we have read about in George Orwell. It is present simply where rational decision-making in the public interest is absent. There's also a notion of Kafka, that idea that you are lost in a maze as a subject of the state, and you're trying to make sense, and no matter which way you turn, it doesn't seem to make rational sense. I just need to save my sound equipment. For example, the Constitution Society said it's also a fundamental principle of logic that any system of propositions that accepts both a statement and its negation is valid, both a statement and its opposite is valid, that is which accepts a contradiction, that fundamentally once you do that, you accept all contradictions. And then that statement provides no basis for deciding among them. If decisions are made, they are not made on the basis of propositions, but they are arbitrary. And that is the definition of the rule of men as opposed to the rule of law. Those of you who have read 1984 might remember that Winston Smith made the statement, freedom is the freedom to say that 2 + 2 make 4. If that is granted, all else follows. There was a case in San Antonio in Texas in March 1994 where a misinstructed jury acquitted all the defendants of the main crimes. They were charged with the main crime and an additional crime. The main crime was robbery. And the judge acquitted them of the robbery. And then Federal Judge Walter F. Smith held that he dismissed the charges on the grounds that it was logically impossible to be guilty of an enhancement if one is innocent of the crime, because the second crime was that they used firearms in the commission of a crime. But the main crime they were innocent on. And under apparent political pressure, he subsequently reversed his ruling and sentenced the defendant to the maximum terms as though they had been convicted of the main crimes. And his comment was, the law doesn't have to be logical. Well, no. The law has to be logical. Otherwise, it is not the law. Then it is arbitrary rule by force. Do you understand this immense, I almost want to say frustration with which we are confronted when a rational argument is thrown against our head? I can illustrate it with this example. And there are plenty of these. That's part of the zeitgeist in which we live. And I thought this is quite a jewel. I don't know if you can read, but it says, whites are oppressors, non-whites are oppressed, but there is no such thing as race. But I love racial diversity, and I celebrate our differences because we are all the same. Therefore, I want to destroy the diversity by mixing all the races, but only in white countries. You understand the frustration. My kids would have had to concede that that's random. It's not rational, it's arbitrary, and yet this is what we often confronted with in the debate. Rule of law is at heart not that. State versus Makonyane was a case in Constitutional Court in which Judge Ackerman characterized the new constitutional order. And here we have to agree with him. He says, we have moved from a past characterized by much which was arbitrary and unequal in the operation of the law to a present and a future where the state action must be such that it's capable of being analyzed and justified rationally. The idea of a constitutional state presupposes a system whose operation can be rationally tested against or in terms of the law. Arbitrariness by its very nature is dissonant with these concepts. Okay, so it's basically to make rational sense of the law that people cannot sit and exercise discretion like tyrants. A tyrant is very often someone whose mindset is a bit like playing. He does what his whims dictate. And all people are like that ultimately because we are fallible. We have incentives to act in certain ways in our own interest or in friends' interest. And when the moment that happens, it becomes arbitrary, and the rule of law must ensure that there's consistent treatment. The rule of law must ensure that the acts that are performed or the statutes that are enacted or the rules that are made are rational and consistently promoting the public interest. Okay, the Economic Freedom of the World Index, which I'm sure Dan is going to tell you more about, has 5 elements to determine whether a country is economically free. They are size of government, sound money, regulation, freedom to trade internationally, and legal system and property rights. The last one largely, not exclusively, but largely deals with the notion of the rule of law. So it's something to bear in mind. The rule of law is part and parcel of what we describe as a free market system, a free enterprise system, as opposed to an anarchist system, which does not even have a law by the looks of it. But you'll explain to me, I still don't understand it. But what you do need is you have to have a law and courts to enforce the law at the very least, because you have property and somebody must protect your property against confiscation or damage by other people. So you must have a law which says you can't take my property, and you must have a court to adjudicate a dispute around that. Likewise, the second leg of the free market system, the first being property, private property, the second leg is freedom of exchange, voluntary exchange, or freedom of contract. Freedom of contract is meaningless unless you have somebody who can adjudicate in a fair manner over the contract. So that is why the rule of law is important to a proper functioning of the market. Now I've looked at the countries that qualify as more or less free market countries, say the top quartile, the top 25% of free market countries in the world. And I couldn't find a single one of them which does not have a very high component of the rule of law. So the rule of law is a cornerstone of the free market system. Now let me give you a sense of why this is so. And I want to do that by reference to the price mechanism. It struck me a few weeks ago that where the proponents of socialism go wrong is that they don't have a criterion to determine value. They have no value. Now the word value is loaded. It has two meanings, but they are related. The one meaning is, how much does something cost? What is its value? How much does it mean to me? What is its value? And secondly, what are your values on a normative scale? And I believe those two are very closely related. And if you take away the sense of value, that somebody can value something, what disappears also very often is the second one, and I'll demonstrate to you why that is so. In a free market, everybody knows that the only way you can acquire something is if you pay for it. And the only way you can pay for it is normally because you've created value yourself. You've either worked very hard in a factory, or you've done something, you've rendered a service, or you've sold something that gives value to somebody else. It's the only way that you can, in fact, give value. And in order to give value, there has to be a price. You have to have free market contract to negotiate a price. And that is extremely valuable because the price is the barometer of how much something is valued. If someone buys something, the two parties agree on the price, which means that the purchaser in particular knows what it is worth for him to get. There's no such thing as objective value. The state cannot determine the value of something. It's impossible. The only two parties who can actually determine the value are the parties who are involved in the transaction. And the reason is the one has to work for it and the other one has to get rid of it, alienate it, pass it over. And that's a rational approach because they both serve their interests. And the wonderful thing is this: at the end of the transaction, they're both better off. It's unbelievable. Whatever they sell, like the man and the two guys who meet each other in the desert, and the one has a can of water, but he's hungry, and the other one has a bag of food, but he's thirsty. Don't tell me that that bag of food and that can of water, in either case, has an objective value. It only has value for the party acquiring it, in the subjective evaluation of the party, but it's perfectly rational in that situation. If they had to exchange money, the guy dying from thirst will give up a fortune, and that would be a perfectly rational solution, and both he and the recipient would be better off after the event. But the modern idea is different. The modern idea is arbitrary, namely that the wealth must be redistributed from the rich to the poor, from each according to his ability, to each according to his need. Question is, who determines your ability and who determines the other party's need? There is no objective judgment that you can bring to bear on that. If the state tries to do that, that is going to be arbitrary. It's irrational. Another way is, and I like the homeliness of this little quote. Some of you will have heard it. It's ascribed to Dr. Adrian Rogers in 1935 to demonstrate how irrational it is to think like that. You cannot legislate the poor into freedom by legislating the wealthy out of freedom. What one person receives without working for, another person must work for without receiving. The government cannot give to anybody anything that the government does not first take from somebody else. When half the people get the idea that they do not have to work because the other half is going to take care of them, and when the other half gets the idea that it does no good to work because somebody else is going to get what they work for, that, my dear friend, is about the end of any nation. You cannot multiply wealth by dividing it. It's irrational. It's arbitrary. Instead, what should happen is a voluntary exchange. Now, let me deal with the first topic that I promised I would discuss. It's crony capitalism, very briefly. Again, a very famous quote and sometimes abused one. That you probably won't be able to read, but I'll read it for you. That's Ayn Rand in 1957. And just tell me this is not familiar. When you see that trading is done not by consent but by compulsion, when you see that in order to produce you need to obtain permission from men who produce nothing, when you see money flowing to those who deal not in goods but in favors, when you see that men get richer by graft and pull than by work, and your laws don't protect you against them but protect them against you, when you see corruption being rewarded and honesty becoming a self-sacrifice, you may know that your society is doomed. That to me gives a sense of this notion of cronyism or crony capitalism. We have many examples in South Africa, state capture being the most prominent one, but tenderpreneurship is one, and I happen to believe that in most cases, so-called BBEEE. It is clear that there's a failure of the rule of law. Now, my concern is, I've already shown to you that the rule of law is an essential cornerstone of the free market. But I want to go so far as to say if we're really serious about freedom and prosperity, the rule of law is not going to be enough. We also need the free market. And just think about this logically. By the very definition of an interventionist state, a socialist state or a statist government, that is a state which goes beyond protecting people's property and people's right to contract and their lives. The interventionist state intervenes by using government authority to influence the outcomes of the market through the application of political force. So the very business of the interventionist state is the buying and selling of favors and privileges. So when they tax you, they use it for favorite programs and projects. They impose licensing and regulatory restrictions. And they transfer great amounts of income and wealth to different groups. Redistribution for previously disadvantaged redress and that sort of thing. Paternalistically imposes legal standards which determine how we must live. Now the government wields these powers and they hold virtually all of our fate in their hands in doing so. Some people will say that the bribing of people with political power is the only means to attain their ends. And this may be to restrict or prohibit competition in their own corner of the market. For others, bribing those who hold the regulatory reins may be the only one way to get around the restriction. The business of the interventionist state is the buying and selling of favors and privileges. So that is fundamentally what it means. And that, as Dan will show to you, is fundamentally to undermine our freedom and our prosperity. In South Africa, the biggest corruption probably is state capture and tenderpreneurship. Now, I grappled with this because I look at our rule of laws. We've got this fancy constitution. It's really, it's hail all over the world. And we've got all these wonderful trappings of rule of law, government. And yet, it's still a spectacular fail on so many fronts. And the only way I can explain it to you is a bit like the old Farmer Brown ad, which I will corrupt by saying, they eat so good because it tastes so good. So what I've done is I looked at the impact of the rule of law in this way. Forget how I calculated it, but in the left-hand corner, left-hand column is a composite rule of law point, and then I divided them all up. Now the independent variable is on the right-hand side. I did that list first, and then I tried to work out the correlation on the left-hand side. And you'll see the more corruption you have, or rather the less corruption you have, that's a high point, means less corruption. The more market freedom you have, that's a rank, it's the closest to the number 1 in the world. So if you an average of 27 in the first quartile means it's very free. 101 in the fourth quartile means very unfree. So both the rule of law and market freedom, both correlate with high or low corruption. The higher the freedom and the higher the rule of law, the lower the corruption. But I was more interested in a second part, and that is this one. I wanted to find out about favoritism, and I found a question in the Global Competitiveness Report which deals specifically with what I've just earlier on pointed out to you about favoritism, state favoritism in business. And I was surprised to find that there seems to be a stronger correlation on the market freedom side. The freer your market, the less the favoritism seems to be, and vice versa. Whereas on the rule of law, there seems to be a correlation, but it's not quite as compelling. So what I'm saying to you is, the rule of law is an essential part of a free market, but I don't think the rule of law can come to its right, work properly, unless there is also a free market. That's when it's worth most. To come to the second example, the protection of private property, I would like to show that the denial of protection of private property is virtually guaranteed to result in a state of tyranny and oppression. Now, to do that, let me first say it is a controversial point whether the protection of private property is part of the rule of law. To me, that shouldn't behove of much debate. You remember the principles that I've spelled out of universal application, non-discriminatory treatment, fair process, and so on. Most importantly, perhaps, property may be expropriated only in the public interest. Whenever there's a proper protection clause in the Constitution, it says it can only be expropriated in the public interest. So there's already a hint that it is part of the rationale of the rule of law, which is to protect the public interest. It's not permissible for an official or a politician to expropriate property for the needs of a person, a political party, or a politician, or a body, or a family. That already embodies the central value of even-handed, public-spirited decisions. Secondly, property may only be expropriated against payment of fair compensation. Remember what I said earlier about value. If you don't have a fair compensation system, and that's really should be a market price, you don't have a value. And if you don't have a value, it means that the right which you are expropriating is not acknowledged. But if you are compelled to expropriate against a fair value, without exceptions, then every single property owner confronted by expropriation claim is even-handedly entitled to fair compensation. And thirdly, compensation in terms of all the rule of law countries must be set by a court of law, which contains in itself the idea of due process and fair and unbiased decision making. But what about South Africa? What about saving the debate by saying expropriation without compensation can be done for the ostensibly noble intention of expropriating to provide redress for the previously disadvantaged? I just want to show to you how irrational that becomes and why it fails the test of the rule of law. The reason is simply that such a process is guaranteed to be arbitrary. Let's say you want to now expropriate properties in order to bring about a just system so as to redress for the wrongs of the past. It can be done in one of two ways. The first way you can do it is by saying property can be transferred in such a way that we give every citizen an equal amount of property. That's one possible way, which would ostensibly be rational and fair. And the second one is to say property can be transferred in such a way that it's aimed at redressing the injustice of past discrimination. So what we do is we play with the notion that we replace people in the position in which they would have been but for the discrimination of the past. Go back, rewind the tape to the day Jan van Riebeeck set foot on the shore, and we say, let's suppose Jan van Riebeeck never discriminated, and all his cronies and all his subsequent successors. We had a fair, liberal society from the word go. What would have happened? And that situation, that is the one in which we must be. Now, you only need to ask the question to see that neither of these two aims, these outcomes, can avoid being arbitrary. The very requirement of equal property, let's go to that one first. Equal property outcomes is arbitrary. Why on earth should everybody have the same amount of property? Everybody is differently endowed with everything. Why should everybody have the same amount of property? There are hundreds of reasons why some people acquired property, and they may be legal and they may have nothing to do with unfair discrimination. Now separate that out from all the other cases where supposedly somebody did inherit something because his grandfather took something somewhere, which was unfair because of discrimination. Try and unscramble that egg. It is impossible. You're bound to end up with an arbitrary result. Take the second scenario, trying to compensate the previously disadvantaged to place them in the position that they would have been but for the discrimination. There is no reliable way. Just take this. Let's imagine what would have happened if the whites who arrived in the Cape treated locals fairly and without discrimination from the start. What would have happened? Imagine that. Everybody got the right to buy property, everybody went to school, everything was fine. What would have happened is that white people would probably have been richer than they are today. Why do I say that? They probably would have owned more properties than they own today. Why do I say that? The reason is that the black workers working in their factories and developing their properties and their farms would have been better trained because they would have gone to school. The property owners and the business owners would have been able to sell their wares and their services into a far better trained market, a far better, richer black market. That must have been so. So white people would have been even richer than they are today. So the very principle of allocating property on the basis of what would have been is bound to be arbitrary, and you're going to burn your fingers. The very principle of allocating blame, guilt, or entitlement on the basis of skin color is designed to ensure an arbitrary and discriminatory outcome. Skin color cannot be an accurate proxy for disentitlement. So no process of expropriation without compensation that is not adjudicated between specific individuals. If John took his neighbor's land and one happened to be white and the other one happened to be black or pink or yellow, doesn't matter. A court can sit and adjudicate on that dispute because it's easy to see who was wrong and who was right. Now this difficulty of quantifying the redress is no small matter. It goes to the very heart of the problem. Because if you make it group-based, as we are told it must be made, and I don't think the property debate escapes that requirement, it's group-based. Secondly, arbitrary, that's no small matter. Because there will always be a fight, an argument. Two things. Some people will say we don't get enough property because our neighbors got more property. And secondly, others will say, well, we didn't get enough property because the redress is not complete. As a matter of sheer logic, we will not know when the redress is complete. Now, in a society like ours, what happens is that the property owning class, call them that, tolerate some expropriation. We all get expropriated every day through tax. And the problem is that that expropriation is never enough. So if labor laws are not good enough, the government introduces employment equity. If that's not good enough, it introduces BEE. If that's not good enough, it introduces social grants and then property without compensation. The point is that freedom cannot increasingly be infringed without sooner or later resulting in a loss of trust. The amount of trust the government enjoys is loosely calibrated as a measure of its legitimate power. So logic dictates that the perpetual infringement of freedom, dignity and property of subjects is likely ultimately to lead to extreme force. How else will we resolve this? More draconian measures will come every time because you will never have a judge who will objectively be able to arbitrate and say this is enough. Finally, when you are to comply with the law, I said to you earlier, you must know when you comply, how you comply with the law. The property owning class is going to say at some stage, but how much property to whom for how long? When will the redress be complete? They are justified and reasonable in asking that because that is not in compliance with the rule of law. Thank you.